Ms. Reynolds.
I feel like I'm so loud. May it please the court. My name is Patricia Reynolds. I'm here today representing Jabari Walker. This is the second time I've had oral argument in this case. It was orally argued in front of the Court of Appeals. Basically, there were a couple issues raised in the brief, but the focus of the application for further review was the issue regarding whether or not he gets an enhanced sentence, and I'm guessing that's why we're here today. Mr. Walker was convicted in Lynn County of kidnapping in the third degree, and the district court ruled correctly that the sentence should not be enhanced because well, first of all, the court set aside the question of whether or not his previous out-of-state conviction was a sexually predatory offense and concentrated on the Iowa, the instant conviction, and ruled that it was not subject to the sexually predatory offense enhancement. It's a cross appeal. This was raised by the state. That was the state's part of the appeal, and that's why we're here today. It's interesting, this case, that in a way the facts aren't terribly relevant. It's confusing to look at the facts, but we have to look at the facts in terms of the jury finding. The jury did not find that there was a forced sex act in this case, and yet there was pretty clear evidence there was a sex act. So I think at some point in the record, the district court says, well, I mean, it seems wrong to try to figure out what the jury was thinking, but the only way to make sense of it is that there was a consensual sex act, and then later trying to fit the facts to the verdict we have that Mr. Walker confined or removed, we have confined or removed in this case, Ms. Nguyen in the car or at the abandoned farmstead where they were interrupted or found by the police. So I guess the important thing is that the jury found there was a confinement or removal with the intent to commit sex abuse, not an attempted sex abuse. Not that we have that crime in Iowa, but the statute is written, the 901A, 901A, talks about an attempt to commit an offense, anything under 709.
Doesn't this case Ms. Reynolds, doesn't it come down to this? Because as you point out correctly, the jury found that there was confinement or removal because there was a kidnapping conviction, but it wasn't first degree. They did not find that there was an act of sexual abuse in the course of the confinement or removal. They simply found there was intent to commit sexual abuse. So the question is, in that scenario, given those jury findings, is it ever possible that the confinement or removal would be a mere preparation, that is not enough to establish an attempt under our common law of attempt? Isn't that what it comes down to?
I've given this a lot of thought. I mean, the best fact sort of scenario I can come up with, and I think it fits your question, that it would fit the kind of confinement or removal. I hope this answers your question. I mean, I think an assault with intent to commit sex abuse is pretty clearly grab of the wrist, statement of an intent to commit sex abuse. You know, that's assault with intent to commit sex abuse. Now, if the perpetrator confines or removes to the point where there's a reach for the genitals, I mean, that's the best scenario I can come up with. That's an attempt. That's an attempted sex abuse. So I think, under the finding of this case, under the facts of this case, that we don't have that.
What I'm trying to see, because Apprendi requires that the jury have found all of the facts that are essential to the enhancement. We agree with that. And Apprendi was decided after the predecessor case that's at issue here, Harrington. So we need to figure out, does Apprendi alter the rule in Harrington? Isn't that right? Is that kind of where we're at?
Yes, and thanks to Judge Tabor in the concurring opinion in this case. And I think the problem with Harrington is the statute was completely different at that time. If I'm reading it correctly, I think it really didn't matter in a way whether it was, we're talking about attempt versus intent, the meaning of those two words. And Harrington, I believe the statute at that time, kidnapping was in the statute at that time, for one thing. And I think intent was sort of equal to attempt under that statute. So in a way, Harrington is not applicable because the law has changed. The actual statute has changed. But I certainly agree with the idea that the jury would have to find the attempt going beyond mere preparation.
Yeah, the issue is, did in effect the jury find everything that's necessary? Because if you confine someone or remove someone with the intent to commit sexual abuse on that person, haven't you gone beyond a mere preparation? You clearly have the intent part of attempt, but you also have to have for attempt an act going beyond mere preparation, right? And doesn't the confinement or the removal kind of per se go beyond a mere preparation? That's the real nub of it, isn't it?
Yeah, no, I don't agree because I think, from the victim's point of view, I'm maybe borrowing the facts from our previous case, from the victim's point of view, being closed in a room or taken in a car with that stated intent is not as bad as having someone reach for you in your private area. I mean, because I think that's the only way you can have an attempted sex abuse. So I don't think confinement or removal, I don't think it goes beyond mere preparation. The principles of statutory construction, when the meaning is plain, we don't need to look for ways to make it what we want it to be or what we think it should be. We look for the evils to be remedied, and I think that's why I'm emphasizing what is more offensive to the victim. An act, whether it be a grab of the wrist or put in a car or door locked in preparation, with credible words to say a sex abuse is going to happen, that's just not as bad as somebody actually trying to use the plain language of our uniform jury instruction, a perpetrator actually trying to sexually abuse the victim. That's the greater evil to be protected against here.
Counsel, neither the district court nor the Court of Appeals decided the question of the legal effect of the Ohio conviction, and the Court of Appeals remanded for that to be determined. But is that an issue, purely a question of law that we should decide in this appeal, or does that need to be remanded for some development of the record?
Right. I think if this court were to decide that the kidnapping third is a sexually predatory offense, I think it would need to be remanded because I think perhaps testimony would, have to be brought up about the facts of that case, the law in Ohio, how it's interpreted, case law from Ohio, all of that. I think it would be more appropriate at an evidentiary hearing.
Let me ask this hypothetical. Supposing a defendant and a victim are at a party, and the defendant says to the victim, I am going to have sex with you, and she says no. He says, well, I'm going to take you behind the barn, and we're going to have sex. He grabs her and pulls her and starts taking her out of the house and heads beyond the barn. Is that an attempt?
I think that's assault with intent to commit sex abuse, Your Honor. I think we have to go beyond that mere preparation. And again, looking at it from the point of view of the victim, that's a pretty terrible thing. But
okay. Well, here, and correct me if I'm wrong, I don't think the record shows, kind of communication about a sexual attempt, but could a reasonable jury decide that there was a specific intent to commit sex abuse and the travel involved and the looking for a secluded place was the overt act to support the attempt?
Well, and it's interesting because I think we have her testimony that he tried to force her to perform a sex act in the car, and yet the jury didn't find that any sex acts occurred. But just looking at it, I think with your hypothetical, that would also not rise to the level. I mean, I think we need a more concrete, move towards the body parts than when it's an attempt. Try to, I think the ride in the car,
would be too remote. The effort to
Yes.
find a private place, in your view, might be too remote.
Yes. And we can look at, we're not looking for absurd results here. To sort of, I guess the phrase that occurred to me is that it would be a stretch, I think, in this case for this court to find that what happened, the jury's verdict in this case amounted to an attempt, that it was like assault with intent to commit sex abuse or confinement or removal with intent. It
But,
wasn't
I
an
mean,
intent.
in Harrington, even though we didn't have the benefit of Apprendi, there was a special interrogatory that answered the intent question. And that was coupled with a false imprisonment verdict that demonstrated confinement. And we said A plus B equaled an attempt to commit a sexual abuse for purposes of the enhancement. And why isn't Harrington just controlling here?
Well,
I mean, they read the same elements, the same enhancement, and concluded that. I mean, Apprendi is not a rule of statutory interpretation. It's a rule that if there's a certain factual issue, it needs to be submitted to the jury.
Well,
Which it was in both cases.
I think the Harrington decision is perhaps too pithy. It's difficult to ascertain exactly what happened. I noticed the district court sort of, I think at some point, interpreted Harrington to say, well, the interrogatory must have said.
Some people say we need to be more pithy now.
The interrogatory must have said that there was an attempt. I mean, I've read it several times, and maybe the best reading of it is that the interrogatory was only intent, which was sufficient for that statute. But it's also possible, and we don't know what the interrogatory was. I guess I could have tried to look at the briefs. I don't know if it's set out in the briefs. But the law was different at that time, so I think there's a lot of arguments for why Harrington doesn't control here. I think we sort of need to look at this with a clean slate because we have a different statute. And kidnapping was taken out. I mean, I think any of the law. I think any way you look at this, it's.
Harrington relied on the elements that are still the same in the statute, not on the parts that were taken out.
Well, I'm not sure that's clear, like I say, because Harrington's so pithy. I think it's kind of difficult to say. We know there was an interrogatory, and we know we didn't have one in this case. So that's the difference that favors the defendant.
Let's talk a little bit about just the facts of this particular case, where we do have the travel to, a rural area. We have it at a farmstead there. Once the police do, in fact, come upon the scene, he is outside of the car. He is on the other side of the car at the passenger area. And then when the police arrive, then she's screaming and comes towards the police. And then then moves to zip up his pants, which is part of the record here too. Doesn't that lend quite a bit of support to a factual finding of the jury that this would have been an attempt?
Well, I think the record is a little murky there. I think it says both parties were adjusting their pants, which just adds confusion, I think, because, I mean, one of the ways to look at the facts was that she was, and maybe the only way to look at the facts is that she was a willing participant romantically with the defendant, and then at some point she became frightened or changed her mind or whatever. But the jury just found that there was a confinement or removal. The jury didn't find that there was any sex abuse. And it could have been a ride in the car.
Intent. They did, however, find specific intent on his part to commit sexual abuse.
Right.
And don't the facts then also support the idea that there was, with this additional facts that we just talked about, an attempt to actually do that as well?
I don't think so, Your Honor. I don't think there was enough facts found there to say that that was, the specifics of exactly what happened.
Well, what would your proposal be then, that we always have to have an interrogatory in these circumstances?
I think that makes sense under Apprendi and then the cases that follow that, Your Honor, that it's the best way to effectuate this statute for the jury to find beyond a reasonable doubt that there was an attempt to commit sex abuse. And since we don't have that in this case, and we're not going to go back and do that, I don't think it has to be found that he does not get the enhancement. that under the facts and the law in this case that it's not appropriate. So I think we talk about the difference between mere preparation and an overt act. I see that I have the stoplight. Thank you.
We'll have some rebuttal.
Thank you.
Thank you. Mr. Buller.
May it please the court. And good morning again, Your Honors. The state's cert action in this case can be decided based on the plain language of the statute. Chapter 901A provides for enhanced penalties for a range of crimes, including crimes that involve an attempt to commit sexual abuse. The statute doesn't say a conviction for attempted sexual abuse because, of course, that's not a crime in Iowa. The language we see is a crime that involves an attempt to commit sexual abuse. And we answer that question based on a fairly simple formula. Specific intent plus an overt act equals an attempt. And we have that here in this case. The jury necessarily found the defendant acted with specific intent to commit sexual abuse.
Doesn't it have to be an overt act beyond a preparation?
Yes, Your Honor. The language this court used in Spies was intent plus a slight act in furtherance of that intent. I think a different way to say that is an overt act that goes beyond mere preparation. And we have that here as a matter of law. Confining or removing someone with the specific intent to commit sexual abuse goes beyond mere preparation. To address your question, you asked my friend from the appellate defender's office. I can't think of any facts where confinement or removal would not amount to more than mere preparation. Confinement or removal done with specific intent facilitates the commission of that crime. And it certainly did in this case. He took her to a rural area in Johnson County and eventually into Lynn County. That facilitated the defendant committing or attempting to commit acts of sexual abuse. I do want to briefly touch this Apprendi issue that I agree certainly lurking in the background of this case, but I don't think it's properly presented in this appeal. There is a pending motion to strike the defendant's notice of additional authorities, and I'd ask today that the court grant that because the Apprendi issue isn't properly presented. It wasn't cited in the district court. It wasn't cited in the defendant's opening brief. It wasn't cited in the defendant's reply brief. It wasn't cited in the defendant's application for further review. The first time the defendant cited Apprendi or any of the cases that deal with that issue was 7 days ago in the notice of additional authorities. Now, today the appellate defender has said that the issue is raised thanks to Judge Tabor, but I don't believe that's true under our cases. If we look at the Phoenix Mutual Insurance case, the court clearly recognized that the Court of Appeals can't raise new issues if they aren't properly raised by the parties. And that's important because judges aren't supposed to be advocates. Courts do better when they decide the issues that are raised and briefed by the parties. And I'd encourage this court to do that here today, to decide the issue that was properly raised below and in the briefing, and that's purely a statutory construction question. The district court's reasoning rested on a claim that intent and attempt are different things. And I think that's right, so I'm not sure exactly where the district court was going there. Intent is the mens rea component of the crime, but of course we also have an actus reus, some kind of action. And in an attempt case, that action is only a slight act in furtherance of the specific intent, and we have that here. I would also say that this question does not involve an illegal sentence challenge because the allegation isn't that the sentence was inherently illegal. It's only that there is a procedural defect in the sentence. The defendant's argument isn't that the enhancement could never be imposed. Essentially, the defendant complains about the process that the court went through to get there. That's a procedural defect that had to be raised below, and it wasn't. So I don't believe that issue is properly in front of the court. But I will say that even if Apprendi was in front of this court, I don't see any kind of problem under that decision.
Back to your error preservation. The district court rejected the enhancement, correct?
Correct, Your Honor.
So you've asked for a writ of certiorari, and in support of what the district court did, they're now arguing that Apprendi required a jury determination of the elements of attempt, which you're saying, in effect, they got. But isn't that what the district court said, that the jury didn't decide the elements of attempt? I mean, I don't quite get it.
I'm not sure.
You're really the appellant here, not the appellee.
Well, that's right, Your Honor. I don't think the rules for error preservation are different in a cert action than they are in any other kind of appeal. Both the appellant and the appellee have to preserve errors on their claim, unless they're evidentiary arguments, which of course we don't have in this case. It's a little bit difficult to make sense of exactly what the district court rested its reasoning on. The repeated statement we heard from the district court was that intent and attempt are not the same thing. But I don't think that's ever been the state's argument either below or on appeal. So I don't think we can find the district court inherently considered this Apprendi argument. Certainly it's not cited. I don't think the concepts of Apprendi about the jury, in order to comply with the Constitution, must make these fact findings. I don't see that anywhere in the district court's reasoning or in the order the district court issued. The reason why...
Isn't it one and the same thing? I mean, the district court found the jury didn't make the essential findings. Apprendi says the jury has to make the essential findings. You don't really dispute that proposition, so why are they raising something new?
Your Honor, it is a new issue because it deals with the procedures that everyone went through at the district court. For example, if the defendant's argument all along had been that the jury should complete a special interrogatory, the state could have offered a special interrogatory at the trial. Certainly the defendant knew this issue was coming up because the enhancement under 901A appeared in the trial information. And then there's a sort of convoluted discussion that happens at the sentencing hearing that eventually leads to the state's petition for writ of...
If you want an enhancement, isn't it your obligation to propose, and a special interrogatory is required at the trial level, isn't it your obligation as prosecutor to propose the special interrogatory?
I don't dispute that, Your Honor. But more importantly, even if the Apprendi issue is in front of this court, there's no Apprendi problem in this case. The holding of Apprendi is that a jury finds facts that lead to the enhancement, that enhance the potential maximum sentence. And we have that here based on jury instruction number 18. The jury specifically found all of the things the jury needed to find because they found confinement or removal with the specific intent to commit sexual abuse. To bring us back to the formula, we have specific intent plus an overt act equals an attempt. The jury found exactly that here. In short, Your Honor, I would just say that the concerns raised by the special concurrence at the Court of Appeals are much ado about nothing. The judge writes at one point of fear that every third-degree kidnapping might lead to an enhancement under Chapter 901A. And that's probably right if the kidnapping is done with specific intent to commit sexual abuse. But of course, that's the purpose of Chapter 901A. The section provides for enhancement for all attempts to violate Chapter 709, which is our sexual abuse chapter. So it makes perfect sense that not only does a defendant who only sexually abuses a victim be subject to the enhancement, but also a defendant who kidnaps someone and attempts to commit sexual abuse. I'd ask that this court affirm the defendant's conviction, sustain the state's writ of certiorari, and reverse and remand on the sentencing issue.
Thank you, counsel. Rebuttal?
May it please the court? I certainly agree with the idea that it's not Apprendi, it's not a new issue, but a way to analyze the same issue that we're talking about, and an important thing to look at in terms of fact-finding and an interrogatory. I mean,
What do you make of instruction 18? It is true, of course, there was not a special interrogatory. The issues weren't broken down, but doesn't instruction 18 suggest that the jury made the necessary findings?
well, I think they only made the finding that she was confined or removed with the intent to commit sex abuse, not that an attempted sex abuse took place. I think there's an important distinction between those two words. Just to kind of go back to the question we talked about earlier, I mean, under the model penal code talking about attempt, the sample from case law that they give is a grab of the throat and loosening of his own pants as a man who was attacking a woman. So, I mean, that's what we would call an attempt to commit sex abuse, that it's a crime in other jurisdictions, that this simply did not go far enough. I think the scenario you gave before about, I mean, it almost sounds like something out of a movie when the guy says, I'm going to marry you someday, you know? I mean, and there, of course, there is some of that in this case, that we have the bar scene, you know, we have the, I'm going to have sex with you tonight under the right circumstances, and a grab of the wrist would not be an intent, would not be an assault with intent to commit sex abuse. It would be flirting in some bizarre alcohol-fueled world.
I've been trying to conceive of a scenario where there would be a confinement or removal sufficient to support a kidnapping conviction with the intent to commit sexual abuse, where the confinement or removal went beyond a mere preparation. And I'm having trouble thinking of a hypothetical where that would be the case.
Well, and I think the difficulty is we don't have those facts in this case because we don't know what the jury was thinking there. I mean, this is kind of a, you know, couple, 3 hours worth of testimony. It seems like, I mean, that the testimony covered that long a period of time.
But if I can't think even of a hypothetical, then that suggests that maybe Harrington is right, that a jury finding of confinement plus intent to commit sexual abuse is enough to support an attempt to commit sexual abuse enhancement under the statute.
Well, if I'm understanding you correctly, I think a woman can, let's just pick women and men, why not? A woman confined in a room with, you know, the intent to commit sex abuse, and the defendant disrobes. I mean, that's a further step. Touches her in some way when he's disrobed. I mean, that's more than mere preparation. I think the confinement in a room or in a car is the preparation, whereas, you know...
You're saying you could have a scenario where, say, take something like the prior case where the person's locked up in a room, maybe with keys on both, you can't just turn the knob and open the door, truly locked up, and the person intends to sexually abuse the victim later on, and that might allow a kidnapping with intent to commit sexual abuse verdict, but the confinement might not be enough to be more than a mere preparation. Is that what you're saying?
Well, I think I understand you correctly, yes. I mean, our definition of sex abuse lists all those body parts, you know, and I think there has to be, because attempt means to try, I think there has to be an attempt to get those body parts closer together, you know, which we don't have with just confinement or removal. To try to commit sex abuse, I think it has to mean more than words and a door being locked or a car being driven away. I think it has to be, from the evil we're seeking to prevent, from the victim's point of view, it has to be more of a try to get those body parts together, whatever they are. You know, we have a lot of them listed in the statute. So we would ask that this court find that the district court was correct in regard to this enhancement, and that Mr. Walker's case should not be receiving an enhanced sentence. Thank you.
Thank you as well, Ms. Reynolds.